Welcome back to Fleischer Studio. Before we even get into the courtroom exchange, understand what you're about to witness here is not just a routine bond hearing. This is a high-stakes identity and public safety battle inside the justice system. We are stepping into a moment where a defendant is already flagged for armed robbery allegations, probation history, and multiple jurisdictional concerns. And the judge is essentially forced to decide one thing. Is this a case of rehabilitation, or a repeating cycle of danger? What makes this hearing so intense is the tension between two narratives. On one side, the court is focused on risk assessment, prior compliance issues, and public safety obligations.
I know that you're going to tell me it's little bunnies jumping in the woods, it's not that big of a deal, yada, 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 but my primary concern is public safety. We have enough death, dismemberment, and hysteria in Harris County as it is, and I don't want any more blood on my hands, you know what I mean?
Yes, sir.
Shh. So, your lawyer is asking me to set you a bond, and I don't know, because if you're a public danger, I'm gonna have a hard time doing it. Right?
Understandable, Your Honor.
Oh, Miss Chisholm's not even here.
She just jumped off because she was just up there.
May I speak, Your Honor?
Your lawyer's not here,
Okay.
so until your lawyer gets back, I'm not gonna let you go. I'm gonna bring you back out, but your lawyer's not here. I can't talk to you without your lawyer here. So I'll bring you back out here as soon as she gets back, and then we'll go right through the rigmarole again, okay? Sorry, I didn't even realize she's not here. Mrs. Thurman, you're back. Okay. So I told you before, two of my main concerns are, or my two main concerns are, number one, are you going to go back to the jurisdiction where you're wanted from? And number two, most importantly, are you a danger to my public? I take public, safety. It's as important as my hair. You know what I mean? It's that important, right? Because I don't want anything to happen out there with my name attached to a bond. I try everything in my power to ensure that everybody's protected. And I see that you're wanted for a really serious case. It's an armed robbery, right? I mean, that's what you're wanted for. There's no denying it. That's what it says on the paperwork.
He's on lifetime probation in Michigan.
Lifetime? There's such a thing as lifetime probation?
Yes.
Whoa.
So that case, I'll let you do the talking.
No, he did his time and he got out, and lifetime probation out of Michigan. So that's what's happened. I believe it got.
So how on what would, aside from like a murder case,
So he was
what
charged
would
with
garner?
murder twice, along with 2 armed robberies.
I wasn't charged twice for no murder.
It just shows up.
It just shows up
Oh, I was about
twice.
to say, I wasn't charged
Murder
twice.
along with armed robbery or aggravated robbery in our jurisdiction. He's placed on probation. Since that time, he's been charged in our jurisdiction with aggravated assault with a deadly weapon and felon possession of a weapon. In those, he had bond conditions when it started off, where he was ordered to have a GPS monitor. He has had multiple curfew violations on top of that noted. And so I do believe he's a safety risk, because even with literally an ankle monitor, he doesn't follow court conditions. And so I believe he is a safety and flight risk. And the fact that there was a weapon involved with.
What's important here is the judge immediately setting the tone. This isn't about debating guilt or innocence yet. It's about identity and jurisdictional control, which is often the first and most critical step in extradition-style hearings. The court is not trying to relitigate the armed robbery allegation at this stage. Instead, the judge is laser-focused on two things. Is this the correct person? And where is this case supposed to be handled? That's why you hear repeated emphasis on identity and jurisdiction. This is where courtroom tension starts building, because defendants often expect to argue facts immediately. But the court is essentially saying that conversation comes later.
Multiple witnesses, some of them children, even threatening to murder them, is that I would be opposed to a bond being set. Also, it should be noted that because of the way the probation was transferred, I can't confirm, so I can't approach on it yet. But from what I see on the system is that he moved the probation to Texas, which means there's an ICA. But I don't have the documents, which is why I can't present them. If there's an ICA hold, he's ineligible for a bond, because that's an ICA hold. I don't have it, which is why I can't say. But if I get the documents.
Interstate compact agreement.
I understand. May I speak, Your Honor?
Of course.
Okay. After we talk about the probation, I'm at the probation, the GPS curfew wise, my judge knows all that was going on. So he knows every information and why I've been late. I have evidence of why I'm late. So he knows everything that's going on with my GPS.
You're not supposed to be late.
He knows why though. So
I understand
that.
that.
That's why he overlooked. He said, "Okay, it's fine." He said it was fine.
Quick question: is it a motion to adjudicate?
Well, no, it's still an open case. It's not under probation, but you're just asking if they do a bond violation report. They did on November 1st, 2024. They filed a motion to revoke.
Oh, so it's recent.
It's very recent.
So they've not
this
heard.
month.
Okay, and then so there's not been a hearing on that yet, right?
No. But that's even after they amended the order. Also, he has further bond violation reports on December 18, 2023, another one on November 28, 2023, and that's after they amended it twice. One moment. So he seems to be agreeing with this. So the fact that he has 3 violations on top of having lifetime probation and a possible ICA, obviously, I'm still opposed for him.
Why are you on lifetime probation?
That's the way they set it up as. I took the plea deal.
What are you on probation for?
The armed robbery conspiracy committing armed robbery. I did 5.5 years. Came home off lifetime probation. And to continue what I'm saying, I'm a threat to, a flight risk. I can't be a flight risk. Every court that they set, I came every single time. Every court that Michigan have set, I flew out there every single time. I knew I was getting locked up Monday. They told me that Thursday. I still showed up to court and got locked up. So there's no flight risk in this whatsoever if I've been showing up every single time.
And you may be showing up, but at the end of the day, you continue to do what you want to do without regard to bond conditions.
And what do you mean by that, Your Honor?
Meaning that they put you a GPS monitor, and they give you a curfew,
Yes.
and you don't abide by the curfew.
I was working, Your Honor. That's why the judge has extended, because they had my probation curfew time at us. I forgot what time it had as. But I had started my new job because I came, got locked up, lost my other job. He said, okay, the violation he's talking about, I came into court and talked to the judge, and he extended my curfew. He was like, okay, you've been working. I said, yes, I have documentation of new work. So I'll show all my documentation, and he said, okay. So the stuff he's mentioning violations for, they already been taken care of. So he's not stating that either. He said 2023 is, obviously I'm still free, right or wrong. I'm still free. That means he's seen all the paperwork. I came with legit paperwork.
And that's kind of where I was coming from at it. If it's a lifetime probation and it's curfew violations that he's still out, my speculation would be that he was able to make an explanation to the judge, and that's why he's not been revoked. So he's still here. As to the underlying charge, it's still a charge and that's what it is. Like he said, he turned himself in on Thursday knowing that he was going to get arrested and held. And so I'm sure that Michigan it's a probation violation because of the underlying charges. And plus, that's where that MRP is probably coming from. I believe he's proven time and time again that he's gone to Michigan, taken care of what he needs to take care of, and he will still be here he's been on bond on the underlying case for about a year. Your Honor, he's not been locked up this whole time up until this recent arrest. So, and at this point in time, this is really just for since we don't have proof of an ICA, if the judge is willing to set a bond, how much that would be, if there's a willingness to set a bond.
Let me read this to you.
Yes, Judge.
Okay. Texas Code of Criminal Procedure 17.03, NLR, out of state Michigan, armed robbery, armed robbery with a conspiracy, 2021. Probation transferred to Texas 3/2021. Concurrently charged with murder, which was dismissed. No holds. Defendant is not indigent, and defendant is alleged to have gone to complaining witness's home and pointed a gun at complaining witness and complaining witness's 3 children, because one of the complaining witness's children was involved in a dispute with defendant's sister at the child's school. Defendant threatened to kill, quote unquote, everyone in the home. Defendant then left complaining witness's home and came back with defendant's father, both ready to fight complaining witness and complaining witness's wife. That's the aggravated assault that we have now. So, knowing that you're on lifetime probation for a very serious case, you know that you're supposed to be out there with a halo over your head. And yet you pick up an aggravated assault with a deadly weapon, where allegedly a gun is pointed at kids. I mean, the way your mannerisms,
Say something, Your Honor, that's why.
but don't though. You have this open case.
Understandable.
Everything they can say, they can use it against you. My concern is public safety, man, and you got to understand that. I don't know if you're guilty of this offense or not, but the problem is bad stuff keeps happening to you for some reason. It's like somehow, sometimes people are their own worst enemy. They get out and then something happens and then they just end up picking up another charge. It's like a cold. You pick up another charge, you pick up another charge here, you pick up another charge there, you don't follow bond conditions here. You know, Mr. Thurman, you scare me, man.
Did I scare you, Your Honor?
Yeah.
And I've been out for a whole year since this case happened, and this is my first time being into this courtroom again, and you're fearful for whose safety if I've been doing nothing but right and working.
That's not true.
That has been true. I've been out for a year on bond and have not been into this no courtroom, but in Orange Jump Shoe, I should say. Your courtroom, anybody's
you
courtroom.
want me to reward you for being
I'm saying,
a good
but you say you're
person?
in fear. You say you're in fear for safety. That's what I'm saying. Like, who are you in fear of? I have not been into any trouble whatsoever. I've been squeaky clean. Just I bond it out.
And Your Honor, to
You
your,
don't get rewarded for being a good person out there. You know what I mean?
I
You're
understand.
supposed to be like that anyway.
I understand that wholeheartedly, Your Honor. I'm just saying, you say you fear, and I'm saying, how are you in fear if I've not been doing anything? That's showing you, that should show you some type of sign, like, okay, he's never doing anything wrong. So where is the fear come to play? That's what I'm asking.
The fear is really because, you know, when people come here, it's little bunnies jumping in the woods, rainbows, gumdrops, and then when they get out there, they turn into different people. It's like Jekyll and Hyde, and I don't want that. Like I don't want someone out there to suffer because we let you out. I let you bond out. You've got an armed robbery, you've got an ag assault. You continue to violate conditions on those bond, right? That shows me that you're not willing to abide by bond. I mean, quite frankly, you're lucky to even be out on those charges with the ankle monitor, and you continue to violate.
Your Honor, you keep saying violate, like, if I was in violations they have on file, by the way. Those have been taken care of. Once again, you keep on saying violations, but they took care of. The felony court judge seeing I have proven, what's the word I'm looking for? Just proven, facts that this is why I'm late. I have a new job. I got fired because I got arrested from other jobs, so I started a new job. For me having a felony in my position, and just call it what it is, a young black man with a felony, it's hard for me to get a job anywhere. So the jobs I do get, I take up on those. So it's hard. For any shift they open up for me, I'm gonna take it and show my work ethic to them. So I let the judge know that. He sees that. He understands, like, okay, that's why you keep on bringing up violations. I have to work, I have to eat, I have to have a house to live in, like anybody else here. So you keep on bringing that up, I'll keep saying, I already talked to the judge about it. He granted it already, he let it go. That's why I'm still free to this day. Well, was free to this day. And you keep bringing that up. You saying threat to your fear, which is understandable. Everybody gonna have fear, but I have not been into any trouble. I've been working. I've been working for a whole year. I've been on my P's and Q's. And like you say, the police report that you're reading, sir, the case is still open, so I can't really speak on it. I'm pretty say much, but it's a lot more to what you're just reading on that police report. It's always gonna be video cameras and house ring cameras, body footage. It's gonna be a lot more other things that you're not gonna be able to read off a police report. It's just understandable.
Just too much blood, Mr. Thurman. I'm sorry. I can't set you on.
Sorry.
It's just too much. I'm sorry. Hey, this
You do
isn't.
not walk away.
This isn't.
I said, okay, it's fine.
I understand that you're hurt, Mr. Thurman, but look.
I've been doing my best, and y'all sit here telling me I'm the bad guy, and I've been doing nothing but my best of my abilities, working, staying out of trouble. And you're a threat, and I'm a threat to society. Really, for a whole year I've been out, and they just not issue a warrant for me just now recently, and I come to turn myself in, and I'm a threat to society. And people, you fear me for what? I'm turning myself in and show you that I'm not running for nothing. I'm not running for anything. I'm innocent, and I'm coming to show you I'm innocent by turning myself in. But y'all are a threat. You can let go of me, sir.
Stop.
You can let go of me.
You do not tell me how to do my job.
You can let go of me. You got my arm too tight.
Guys, relax. Relax.
I'm too tight. All I said, grab me. Look how you grabbing me up.
Back up.
Look how they grab me. I said you let me go a little bit.
You gotta calm down.
I'm calm. I just asked him a question. I asked him if I should let me go a little bit, sir. That's all I said.
Open the door.
That's all I said. When you make somebody cuss you out, what do you think? You think I'm a hard type? You listen up. You know what I'm saying?
So he already waived, so if he
He did.
holds it, then it's.
Just, yeah, I
Yeah,
can't.
I'll go talk to him, but once again, Judge, understandably, I think I know that he's frustrated. I believe.
I understand. I get it. And I would be too, but I can't. That's just too much blood. It's too much. You know,
It looked like there was.
you know what I'm going to tell you, even if he didn't have those bond violations, that'd still be very hard pressed to even, you know.
No, and I was curious because when you brought it up, it was a little bit older, and so I was wondering why.
Do you know, are they going to come get him?
Oh, no, they're gonna get him. I was trying to figure out why now, and they were just having back and forth.
But here's the problem. So he hasn't made bond on those cases. So we're sitting anyways.
Yeah.
He has not.
No.
He said he did.
No, he's not made bond on those cases. He's
He's been
basically,
in jail for a year.
No.
he may have, but they revoked the bond.
Ah,
Yes.
So he's sitting there. I
There you go.
didn't have the heart to tell him right now that the 14 days is not going to apply
Yeah.
because
I gotta do that.
Well,
I really.
would
I
imagine.
will. I'll let him know.
I would imagine it's gonna get resolved because it's one of those. It's a bizarre. So we revoked. Harris County revoked because Michigan revoked because it was charged with the ag assault. So it's a chain of events because the only thing the court sees is that they revoked on the probation, which was caused.
Please
by
let him
race.
know that the 14 days hasn't kicked in and it will not.
It will not kick in.
Resolves.
Right.
And either he resolves the cases.
So which one does he need to resolve first in order for?
Well, for the felon possession of the weapon, there's. Hold on, I don't want to see.
Is there an offer?
No, it's going to trial. That's why it's been reset out. It's been set for jury trial at least
Four
Really?
times.
4 times. 1,
Yeah.
2, 3, 4, 5. Yeah.
5 times, Judge.
Next time is January 6, 2025. But he's held on $55,000 bond for the ag assault and $55,000 for the felon. So he has to come up with $110,000 for.
Wait a second. So
So it doesn't matter what you did today.
can't.
Right.
Even if I gave him a bond today, he would still have to make those bonds.
$110,000.
So my question now is, when did that warrant for the felonies pick? Because he's saying he's been out for a year ever since this
I'll
ag
explain
assault
it.
got picked up.
I show a remand defendant custody on November 18th, but I don't know what the previous.
So the only reason why his felony bonds got revoked was because Michigan revokes.
I should
Oh
say
no,
only.
it doesn't. But we don't know that for sure
Yeah.
because it doesn't. There's no notes that reflect why they revoked the bond. It just says court directive remand defendant to custody. Let me see if they give an explanation. Hold on.
Okay.
This is the turning point where the hearing escalates significantly. The mention of armed robbery out of Michigan completely changes the risk calculation in the courtroom. Now the judge is no longer just dealing with identity confirmation. They are actively evaluating public safety risk and potential danger to the community. That phrase alone, armed robbery, instantly raises the severity level in any bond decision. What makes this moment even more critical is the judge explicitly referencing concerns about violence, dismemberment, and public safety impact in Harris County. That language is not casual. It reflects how seriously courts treat potential repeat violent offenders during bond considerations. To this stage, everything becomes about risk management. The court is essentially weighing, if released, what is the probability of harm, flight, or further offenses? And once that calculation begins, bond decisions become significantly harder to secure. Here we hit one of the most legally significant points in the entire hearing: lifetime probation status. When a judge hears lifetime probation, it immediately signals long-term supervision, heightened compliance expectations, and a history that already required extended correctional oversight. This is not a minor detail. It heavily influences how the court interprets new allegations. Even more important is the context being introduced: prior serious charges, multiple jurisdictions, and continued supervision conditions like GPS monitoring. From a judicial standpoint, this creates a pattern being examined. Not just isolated incidents, the court is now assessing whether prior intervention methods actually worked. And when probation history includes repeated monitoring and still results in alleged violations or new offenses, it raises a serious question. Is structured supervision enough to mitigate risk? This is where judges often become extremely cautious, because they are not just evaluating behavior, they are evaluating compliance history under controlled conditions. This section highlights one of the most common courtroom conflicts: technical violations versus practical explanations. The defendant is arguing employment conflicts, schedule issues, and corrected behavior through judge-approved adjustments. Meanwhile, the court is focusing on documented violations tied to probation conditions like GPS compliance and curfews. This is where perception becomes critical. In court, reason does not automatically cancel violation. Even if a judge previously adjusted conditions, the record still exists, and that record contributes to current risk assessment. What we're seeing here is a classic clash between rehabilitation narrative and enforcement narrative. The defendant is presenting context and intent, while the court is evaluating consistency and adherence to rules over time. Now the emotional intensity peaks. The defendant is clearly pushing back against the court's framing of him as a threat, emphasizing work history, compliance, and lack of recent trouble. This moment matters because it shows a fundamental disconnect in perception. From the defendant's perspective, he is demonstrating effort, stability, and responsibility. From the court's perspective, however, prior charges and alleged violations still shape risk interpretation. This creates frustration on both sides. The defendant feels mischaracterized, while the court remains bound by documented history and statutory responsibility to prioritize public safety over personal narrative. This is where courtroom dynamics often become emotionally charged, because the defendant is not just defending legal status, but defending identity. This is the critical decision point. When the judge explicitly states they cannot set bond due to cumulative risk factors, this stage, the court is no longer debating individual incidents. Instead, it is evaluating the totality of circumstances: prior armed robbery allegations, probation status, alleged aggravated assault involving firearms, and documented compliance concerns. When a judge says, "It's too much," what they are really communicating is that the risk threshold has been exceeded for safe release under current conditions. This is also where judicial discretion becomes most visible. Even if there are arguments in favor of release, the court must prioritize the possibility of harm to the public, which in this case is being weighed heavily. To summarize this hearing, the court was ultimately dealing with a complex mix of out-of-state charges, probation conditions, alleged aggravated assault, and prior compliance issues. The central question was not just identity, but whether releasing the defendant would create an unacceptable level of risk to the community. After reviewing the history, allegations, and probation context, the judge determined that setting bond was not appropriate under the circumstances presented. The decision reflects how seriously courts weigh cumulative risk, especially when prior supervision and monitoring conditions are already part of the record. If you look at this case as a whole, it becomes a clear example of how past behavior, current allegations, and probation history can intersect to influence judicial outcomes in a very significant way. If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.